Good morning. This is Dr. Ahmed Sharafuddin. I would like to give you some hints about two points. First, how to resolve a case, and also a kind of questions called false or true, and state your reasons. After this, I will revise with you some important point regarding the sources of law. I believe that Dr. Fatma has explained for you sources of law, but I would like to revise some point in such subject. First, I believe that I launched on the platform a list containing some cases and question called false or true. So I would like to give you some the step by which you can have the full mark on these two kinds of question. So I start by cases. I believe that you know that we have at least 4 steps for resolving cases. First of all, I will give you an example at the end. The first step is to state the facts which is written on the paper of the exam. So you will reformulate the facts by your style. Don't make it as it is written on the paper. You can change the wording, but you keep the meaning. So that is the first step. Second, legal problems raised by the fact. So you will analyze the facts and you will give us the related legal rule to be applied on such fact. Third, applicable rule or rules. So in the case before you as a judge or a lawyer, you will find that appropriate rule to be applied, such rule, and you state the content of it. It doesn't matter if you cite, if you say the number of the article. It is not important. The most important thing is to find out the rule which you will apply on the case before you as a judge. Fourth, the proposed solutions. You can propose more than one solution for the case. If you are not sure about the correct solution, you can find, you can state two solution, and you give your legal ground. Finally, it is not necessary to find out, to state your personal opinion, but it will be beautiful if you give us your opinion about the result of applying law or legal rule on the facts before you. I believe that Dr. Fatma has analyzed with you some cases, and the most important thing for me is to be creative. That's to mean you create you express your opinion, either in stating the facts or on applying the legal rule on facts. I believe that you have a case stating that someone has given a present to his friend on his marriage, but the latter has not been rendered the same for the former, for his friend. The question, if the first person can emanate or make a lawsuit, da'wa, يعني, asking the judge to oblige the person who has taken the present to render it or to give his friends a similar or no. You can formulate the facts, I summarize it, but important thing is to find out the legal problem. The question, if such fact, such demand, such a claim, talab, is legally sanctioned. I mean, can the judge oblige a person to give his friend present on his marriage, it is not legal problem. It related to tradition, to courtesy, اللياقة يعني. So there is no legal problem here. So the judge couldn't apply the law because there is no legal rule obliging us to give our friends present at their marriage. That's why I give you the freedom to analyze it and to find out perhaps another opinion about the decision of the judge. So another example of false or true, I will give you at the exam. I will give you a statement, ask you if it is true or false, and please, if you find it false, please correct it, make it correct. For example, commercial law is the law which describes acts considered as crime. False or true? I believe this is false statement. Commercial law is dealing with commercial acts and contract, not crime. Another one, individuals may never exclude the application of any legal rule by their mutual agreement. I believe it's false because we have studied that legal rule can be divided into two kinds, one mandatory, Amira, and other complementary, supplementary, mukammila. The latter one can be derogated, can be we can agree against contrary to its provision because it is complementary. And the opposite, mandatory rule, couldn't be agreed upon its elimination. استبعادها يعني. So such you can find the correct answer, false or true, but be careful when you correct the false statement. That is all the things which I would like to explain for you under the head of the first point concerning examples of questions which can take the form of cases or false or true questions. Second, I believe that Dr. Fatma has explained you the sources of law. We have two kinds of sources. The first, formal sources, المصادر الرسمية, and the second, informal resources. The second one will not be the subject of our explanation. I will give you some hints about the sources of law. We can summarize it under four head. One, legislation. Second, custom. Third, Islamic law. Four, natural law. So I start by legislation, which is a function of People Assembly. That's to mean House of Representative, Majlis al-Nawab. You know the kinds of legislation: constitutional, disturi, and normal legislation, التشريع, and subordinate legislation or regulation اللي هي اللوائح. So you notice the hierarchy between such three kinds. As the first rank comes constitution, after it comes legislation, after this comes subordinate legislation. So I believe also we must take something about judicial censorship on legislation. Legislation mustn't contradict with the Constitution, and subordinate legislation cannot derogate with ordinary legislation. The second source, custom. What are the elements of custom? Two. Element of customs, two. material one, old habit, a habit. People make the habit regularly, and an act people make it usually, and it becomes habit. Moral element, people feel it is binding upon all this habit. يبقى two element, habit plus feeling of people that such habit is binding upon all people. So the second element, moral element, distinguishes between custom and what is called agreed usage, العادة الاتفاقية. So for example, in restaurant there is a agreed custom, agreed usage, that you pay 10% as a service, So it couldn't be done without the agreement of both parties. I must agree that I will pay 10%. Why? Because it is not a custom. This is agreed usage. So you must be able to distinguish between custom and agreed usage, and I believe there is a case on such topic, like who will have the ownership of the furniture after the divorce between spouses. There is a custom saying that is belonging to the wife, unless there is a opposite proof or opposite evidence. So that is a custom. But 10% at restaurant, it is agreed usage. The position of custom, it is a little bit difficult, but I will summarize it. The legislation, ordinary legislation, may ask the custom to help it in order to determine the scope of application of ordinary legislation. For example, you will study on second year that it is forbidden for a creditor دائن to have from the debtor من المدين composite interest, يعني الفوائد المركبة. يعني that's to mean the creditor ask debitor to give him interest on interest. No, except if it is the custom on in the commercial act. This is what the civil code says. So I refer, the legislator refers to the custom in order to determine the content of some idea, like composite interest. Custom contradict with legislation sometimes, yes, if legislator allows this. But the most important thing, if without the special text on ordinary legislation, custom may contradict the ordinary legislation, there is a controversy between jurists, خلاف يعني, but the most important opinion says no, because if the custom contradicts ordinary mandatory rules of ordinary legislation, it will not become a custom, because custom has two elements. One habit. This habit mustn't be contradict order public or mandatory rule. That is to mean in such point you will find more than one opinion, but you may choose to, as a judge, to apply the last opinion saying no, the custom couldn't be contradict with mandatory rules. Third source, principles of Islamic law. Sometimes ordinary legislation is stemmed from Islamic law, like inheritance. المواريث in third year you will study inheritance. The law of inheritance has its source from Islamic law, المواريث. But we speak here about the Islamic law as a formal source. Could the judge refer to it? Yes, but in third degree. This is the first rule of civil law, saying if the judge does not find a text in legislation or a custom, he will apply Islamic law. What is the meaning of Islamic law? You will study this in the first and second year. But here for introduction to law, it is enough to say that we mean by Islamic law for the judge to find out sources of law. We mean Hanafite school, مدرسة الحنفية, مذهب الحنفية. For non-Muslims, المسيحيين اليهود يعني, if they have the same sect, المذهب and faction, الملة, they will be subject to their special الشريعة بتاعتهم Orthodox, الكاثوليك مثلا. But if there is a difference between two spouses as to their sect, واحد Orthodox وواحد Catholic, no, we will not apply any special legislation. In such a case, we apply Islamic law. Last source is principle of natural law and rules of justice. As you say, it is not a clear wording, but the legislature means by natural law and rules of justice to give the judge a source to find out by his reasoning, باجتهاده, the rule to be applied on the dispute before him, because there is no any text or rule in another sources. So the judge will find out by his reasoning, باجتهاده, the appropriate rule to be applied. In general, he will find the rule required by human right, by the common sense. So he will apply it. Otherwise, he couldn't say, I don't find a rule to be applied. Otherwise, he will be committed crime which called denial of justice, إنكار العدالة. He must find a solution for the dispute before him. That's all what I need to say for you, and I believe that if you need anything, please speak with Dr. Fatma, and I will try to explain what you need in the next classroom. So have a nice day.